Sure. Well, thank you very much for having me. Interim measures and emergency arbitration proceedings have become increasingly important in international arbitration, and certainly in my experience are used a lot by practitioners and are in front of arbitrators more frequently. As far as the African continent is concerned, of course, it is a natural progression of seeing more and more projects in the African continent, whether it's infrastructure, mining, transport, or other types of projects that are very large in scale. And we see that increasingly parties, of course, are investing in the African continent and are faced with situations where their rights may be at risk in situations where there may be, for example, a change in regime or other types of measures that may be decided that may threaten their situations on the ground. And so institutions, arbitral institutions, have made all at this point really an effort to develop a set of rules, whether it's refining their interim measures after the constitution of the tribunal or creating opportunities for parties to seek emergency arbitration measures from an emergency arbitrator that would enable them to preserve the status quo, preserve assets, as the case might be, just protect their rights or protect their investment pending the outcome of the underlying arbitration. And that can prove to be very beneficial to avoid aggravating the dispute and ensuring that the parties' relationship can continue or at least can be preserved until the arbitral tribunal decides the underlying issues. So in my experience, it's a very commonly used tool, whether in Africa or in other parts of the world, and one that I think is very helpful for both parties alike, depending on the situation at hand, to make sure that they are not seeing any deterioration in their relationship as the arbitration process takes its course. I'm fortunate to have been raised in different countries in the world and acquired education in a number of countries as well. And I'm not an exception. This region, the Middle East region, is very rich with people like me who have had the chance to be exposed to different legal systems, legal cultures, and languages. It has helped me tremendously in my practice. I'm based out of the United States, but I spend a lot of time here. I also spend a lot of time in the French-speaking world, whether it's France, Belgium, or Africa, of course, the Francophone Africa. So in addition to, of course, my fluency in English, being able to work with clients in their native language, being able to work with local counsel in their native language, but perhaps at a deeper level, being able to read the text of the law in these languages and understand the legal tradition that my clients or my co-counsel come from, enables me to really work with them at a level where we can all strategize together and team up together, understand the expectations perhaps of the parties better, approach things and to some extent custom-made our strategy according to what we think the expectations of the tribunal might be, depending on whether they're civil law trained, common law trained, depending on what legal culture they come from. So it just gives us tools to work with what we have, with the plurality of languages and skill set and cultures that we have, to give, to represent the client in the best, most effective way possible. That translates, as I said, in the meeting room with the client, even at the early stages when we're working with clients to craft dispute resolution provisions in a way that we are able to anticipate what their needs might be, depending on what culture they sit in, but also all the way to representing a client in arbitration, thinking about what advocacy style may be most effective for the arbitrators, for the tribunal, also preparing a witness for examination, and thinking about the culture of the witness and and the witness's expectation. These are all because of the practice of the nature of international arbitration. These are all tools that, when one comes from a multitude of backgrounds, it enables us at a deeper level to connect, to expect, to anticipate, and to work effectively, to know what the right approach might be to serve the needs of the client. As a vice president of the ICC Court of Arbitration, I have certainly had opportunities to discuss AI and the importance of AI in today's world and in the practice of international arbitration with the other members of the court and the court's president, Claudia Salomon. As I think other institutions are doing, the ICC is very focused, of course, on ensuring that it integrates AI, as it should, in a way that is safe, that is efficient, that is transparent, and that ensures maximum efficacy for the process of international arbitration. Of course, we cannot ignore the progress of AI, but we also have to be cognizant that we're in a field where you simply cannot delegate the decision-making process to a machine. You have to maintain that with the arbitrator or the tribunal, as the case might be. And so the use of AI can be integrated in the arbitral process so long as it does not take over the decision-making process, so long as it only acts as a support mechanism for arbitration, be it in the form of, for example, creating a chronology or looking at translation-related issues, or assisting the tribunal with relatively simple or administrative type tasks, as long as those are properly disclosed to the parties. So that's in relation to the tribunal's reliance on AI. As far as the parties' reliance on AI, I think the same principles apply. Namely transparency above all, and I think that the use of AI by the parties, for example, in document production, exercises and the like, should be done in a transparent manner. But also an important aspect that one needs to consider when thinking about AI with respect to the parties is equality. As an institution or as any body, for example, even a tribunal, looking at a process, you want to ensure that both parties have equal access to AI, and that that is understood, and that there is perhaps a database or a tool that is equally available to both sides. That is a challenging issue, I think, for institutions at present, and that I know the ICC, of course, is cognizant of, and ensuring that it is used, that AI is integrated, acknowledged in a way that is safe and that does not compromise equality, and of course as well that does not compromise confidentiality and cybersecurity issues and the like. No, other than just saying I'm delighted to be here in Dubai, and I thank the law for having me, and look forward to seeing you again very soon.
We look forward to that too. Thank you so much for
Thank you. So yeah.